Good morning to all of you. Welcome to Legal Matters by Sai Babu Sukar. CPC class. The topic is regarding revocation of the gift deed. Maybe the gift deed, maybe the settlement deed. When once you give some property as a gift out of love and affection, unless there is a repugnant condition, you cannot revoke it. మీరు ప్రాపర్టీ గిఫ్ట్ ఇవ్వటం, బహుమతిగా ఇవ్వటం చాలా తేలిక, తిరిగి తీసుకోవటం చాలా కష్టం. బికాజ్ యు ఆర్ లూజింగ్ యువర్ రైట్స్. He can donate it to anybody, he can sell it to anybody. In the meantime, you can't revoke it so easily. Very, very difficult. Ordinarily. So, Honorable Supreme Court of India, 2 judges bench, Justice Pankaj Mittal and Ujjwal Bhayan, in the case of N.Thajuddin versus the Tamilnadu Khadi&Villages Board Industries. Khadi&Village Industries Board, in CA number 6333 by 2013, decided on 24/10/2024, that is just yesterday, observing that a gift deed could not be revoked ordinarily, and especially where there is no right of revocation is reserved in the deed. If the deed says that yes, you can revoke it on happening of some incident or particular condition, or when it is a contract, 126 of the Transfer of Property Act, like that, you can get it revoked. Otherwise, ordinarily, it's not possible. Right of revocation should be reserved, should be mentioned in the deed. Otherwise, not possible. So, this is the crux of the issue, particular case, dealt with section 126 of the Transfer of Property Act. Now, let us know the facts of the case. Mr. Tajuddin, he has given land in survey number 16/1 to an extent of 3,750 square feet in some village near Kadalur to the Tamilnadu Khadi Board for manufacturing of Khadi lungis and Khadi iron. The condition is that they have to utilize, that means they have to start an industry only for developing the Khadi, yarn and manufacture of lungis, not for other purpose. He executed the deed on 5/3/1983. He executed the deed on so-and-so date, 1983. But what happened is, of course, they have started the industry, they wanted to continue the same, they wanted to get the records mutated in their name. But in the year 1987, he has given a notice for revocation of the deed and he revoked in the sub-registrar office. It was challenged by Tamilnadu Khadi and Industries Board. Of course, the trial court did not agree. They said that when once you relinquish your rights, once you have given a gift deed, you don't have any rights unless it is mentioned with certain conditions there. Not allowed. Then he went to the first, that is district court. District court allowed the same, stating that maybe they are using it for some other purpose, things like that. Nowadays it is quite possible. Later, the matter went to the High Court Divisional Bench, who all unanimously stated that when once the revocation, once the gifted is given, he will relinquish all his rights and he cannot revoke it unilaterally. So the matter has come to the Supreme Court. Supreme Court also, same opinion. Here they have explained section 126 of the TP Act. So there are certain conditions in which the gift deed can be revoked. There are 3 conditions. What are they? This is the important point in this case. Number 1, on the happening of any specified event, if it is mentioned that in case something happens, yes, the gift deed can be revoked. Ante, yes, it can be revoked. Second point, if parties agree that it shall be revoked on the will of the donor, that means if there is a condition that the donor can at any point of revoke the same, yes, it can be revoked. Third point, when it is a contract where it could be rescinded, where it could be stopped, yes, it can be allowed. So please remember, the trial court is 100% correct, because when once you lose, you give a gift, definitely you are losing your rights and you cannot claim it unilaterally without giving notice, and revocation is just not possible. That is what the Honorable Supreme Court of India wants to say. Please read the judgment, section 126 of the TP Act, then you will clearly understand the structure of the case. Thank you.